Good morning, good evening, good afternoon. I know I'm going to be competing with the Surveillance Doze boys over at Fine Fix Finish Productions, but you could always watch this stream later. And if you watch it later, well, there's no commercials because I'm not monetized. Someone had asked me to go over this, and I don't really know why they wanted to go over it. This is Eric Brandt's appeal. Eric Brandt, for those of you who aren't aware of him, he was a very loud mouth, foul, homeless man. Probably did a lot of drugs. I interviewed him once. Nice guy. People thought he was a genius for reasons that I don't know. They justified it by saying that he worked on a nuclear submarine. I guess that makes you a genius, so or whatever. Anyway, he liked to push the boundaries of the First Amendment, and I don't fault him for that. But he got a lot of legal troubles about that. And one day he decided to threaten a judge. He apparently called up the judge's clerk, if I remember correctly, and said something along the lines of like, "I hope you die, and I pray you get to do it in front of your kids," or something quite along those lines. I mean, it was a very thinly veiled threat, and I explained at the time that judges aren't stupid and people aren't stupid, and they would very quickly notice that is in fact a thinly veiled threat. And sure enough, he was arrested for it, despite all of his screeching that he wouldn't be, and he was convicted of it. But no, he wasn't convicted of it. Now, was he? Because the genius Eric Brandt pled guilty, and he pled guilty to all of the charges without getting the guarantees of a lower sentence. So he went in to this swearing that he was not guilty, swearing that I'm dumb and wrong. Me, the first-year family law attorney, is dumb and wrong. It didn't know what the hell I was talking about. Oh no, she didn't have to snitch on him, dude. He called the court's clerk. He called the courts. How stupid do you have to be? There, you don't have to snitch. He called the clerk, the judge's clerk. I mean, you can get mad at Benson all you want, but she didn't have to snitch. Eric called the court's clerk, bro. Quit thinking that there has to be some deeper ulterior something. The dumbass called the court's clerk and made these threats to the court's clerk because he couldn't talk to the judge. He wanted the court's clerk to pass on the message. Don't be fucking retarded, bro. No one needed to snitch. Eric did it on his own. And the dumbass pled guilty to everything. He didn't fight it. And he got not the maximum sentence, but a really bad sentence. I don't remember exactly off the top of my head, but I think it was somewhere like, was it 6 years a pop or something like that? I mean, it was pretty fucked up. He got a long ass sentence for a fucking phone call. Now, I understand it was threatening a judge. I understand that, but it was also a phone call. I mean, he got a long ass sentence. So someone wanted me to go over his appeal. Now, when you plead guilty, it removes a lot of. This is like the mirror image, the exact 12 years altogether. Yeah, it was a doozy. It was a doozy. This case was the mirror image of Earl's case. Earl went all the way through trial and was found guilty, and then he made an agreement for a specific sentence. Eric pled guilty without an agreement for a specific sentence. So two completely different things. Because Eric pled guilty concurrently or consecutively? Because if it was concurrently, he was found guilty in what, 2021? So he'd be almost out, but I don't think he is. See, this is 21 CA, so So yeah, this was 19. He was found guilty in 19. If it was concurrently, homeboy'd be out. If it was concurrently, homeboy would be out. O-U-T. Because even if he got convicted in 2020, it would still be 4 years. Yeah, I'm pretty sure it's consecutive. Consecutive. So concurrent means he's serving all 3 convictions at the same time. Consecutive means he finishes one, then he goes to the next. It's the bad way. It's the bad way. So all he gets to do is appeal the length of the sentences. And the sentences, in case you're missing what's on the screen, in case you're just listening, the sentences were affirmed. The sentences were affirmed. But we'll go over it because someone asked very nicely, and so I am an asshole, but I'll go over things if you're nice. So defendant Eric Brandt pled guilty to 3 counts of attempted retaliation against a judge and was sentenced to 3 consecutive 4-year prison terms. So he's out in 12 years. He challenges the trial court sentences we affirm. So the legal authority and standard of review, this particular section of the Colorado statutes guarantees a person convicted of a felony offense the right to 1 appellate review of the propriety of the sentence, having regard to the nature of the offense, the character of the offender, and the public interest, and the manner in which the sentence was imposed, including the sufficiency and accuracy of the information on which it was based. A review of the propriety of the sentence involves the intrinsic fairness or appropriateness of the sentence itself. A review of the propriety of the manner in which the sentence was imposed involves the extrinsic factors and procedures which affect the determination of the sentence. But if the sentence is within a range agreed upon by the parties pursuant to a plea agreement, the defendant shall not have the right of appellate review of the propriety of the sentence. I don't believe they agreed to them, though. This exception to the right to appellate review has been referred to as the plea proviso. While the plea proviso, if applicable, bars review of the propriety of the sentence, it does not apply to a bar review of the propriety of the manner in which the sentence was imposed. On appellate review of a sentence, the decision of sentencing court must be accorded deference because of that court's familiarity with the circumstances of the case. It is this familiarity that places the trial court in the best position to fix a sentence that reflects a balance of the relevant considerations. Accordingly, a trial court has broad discretion when imposing a sentence. We will not overturn a sentence imposed in the absence of a clear abuse of that discretion. The court abuses its discretion when its decision is manifestly arbitrary, unreasonable, or unfair. In Colorado, our legislature has established that the purposes of sentencing include punishment, deterrence, the prevention of crime, and the promotion of respect for the law, reduction of the potential that the offender will engage in criminal conduct after completion of his sentence, and rehabilitation. Thus, in exercising its sentencing discretion, the trial court must consider the nature and elements of the offense, the character and rehabilitative potential of the offender, any aggravating or mitigating circumstances, the development of respect for the law, the deterrence of crime, and protection of the public. A trial court may properly find certain factors to be more compelling than others and may conclude that the circumstances of the crime alone justify the imposition of a particularly harsh sentence, but the court may not unduly emphasize one factor to the exclusion of the others. Basically, what that means is that the court has a lot of discretion in making the determination, as long as it considers all of the relevant factors. And if it considers all the relevant factors, well, then there's not a whole lot that the Court of Appeals can do. As a threshold matter, we reject the people's argument that, to the extent Brandt is challenging the propriety of a sentence, such a claim is barred by the plea proviso because the plea agreement called for an agreed-upon sentencing range. The plea agreement advised Brandt that he would be subject to a statutorily enhanced sentencing range because he was serving a deferred judgment and sentence at the time he committed the underlying crimes. Things not to do, folks. Things not to do. The number one thing not to do if you are serving a deferred judgment is to commit another crime. Specifically, well, including but not limited to calling the clerk of the judge in one of your cases to threaten the judge. U.S. versus Cordova. I've read U.S. versus Cordova. I don't recall there being anything interested in it, but I could probably take a look at it. Maybe not tonight, but I could take a look at it. The plea agreement, yada, yada, yada. The plea agreement sentencing stipulations or concessions reflected that only that the sentence will be open to the court. So in the plea agreement, he said, I'll plead guilty to essentially whatever the court is going to sentence me to. How fucking dumb is that? How fucking dumb is that? And do you think here's a question. Do you think the public defender said you really should take that? Or do you think the public defender said, well, I have the duty to advise you of this particular settlement offer, but I don't think we should accept it because if you do it, you could get a maximum of, I think wasn't the maximum like 6 years a pop or something along those lines? I mean, it was, well, if there's a sentencing, the base range was like up to 6 years, I think. So I don't know with the sentence enhancement how much it would be. Timmy's been quiet. He's been pretty quiet. After his brothers and or sisters died, he decided to quiet down a little bit, or maybe he's just getting older and quieting down. I don't know. I'm not going to question it. I'm just happy it happened. Therefore, because the plea agreement does not contain a range agreed upon by the parties, the plea proviso does not bar our review of the propriety of Brandt's sentences. In this particular case, People versus Odell, the plea proviso did not apply because the plain language of Section 18-1-409, subsection 1, requires an agreement by the parties to a sentencing range. And although the defendant was advised of the penalties applicable to the offenses to which he was pleading guilty, there is no indication in the record that his plea agreement included any type of agreed sentencing range or cap. See also People versus Schofield for something slightly different. The plea proviso did not apply where the parties, quote, expressly agreed upon, end quote, a sentencing range, even though the range was the same as the statutory aggravated sentencing range. Well, the plea proviso did apply. So if they expressly agree upon the range, instead of just being advised of the range, if they expressly agree on the range, then it's a plea proviso. I'm not a news channel, Jackson. So I don't know. I'm sure someone out there might know, and if they do know, then maybe they will they'll posit an answer for you. Yeah, it's pretty good. It's a pretty good idea. You know, when you're buying a car, you probably want to know what you're going to pay before you agree to buy it. Just probably. The parties also dispute whether Brandt's claim is preserved and thus what standard of appeal or of reversal applies. We deem the cases relied upon by the parties to be an opposite. What the court is saying here is that the cases cited by both parties were not on point. WTT says a federal indictment in Louisiana. Oh, Pink Taco is making some. You know what? I love the entrepreneurial spirit, Pink Taco. I love it. You know, a lot of auditors have had some nice fish tanks. Like, who is that fat older guy out of Texas? I know that doesn't really narrow it down much. He didn't really do a lot of auditing. He just reported on stuff. He had a really nice, well, I liked it, fish tank in the background. Even Diddlin Jack had a fish tank. I mean, fish tanks are nice. If you can afford one, they're nice to have. They calm the nerves. They're soothing. They're peaceful. Instead, because Section 18-1-491 guarantees a defendant the right to appellate review, Brandt did not need to object to the trial court sentencing decision to preserve his right to obtain a review of his sentences. Brandt also appears to suggest that the sentencing judge's ruling reflected an appearance of partiality. We agree with the people that, to the extent that he raises the issue, Brandt waived it by not filing a motion to disqualify the judge. The defendant's contention can only be reviewed for actual bias by the sentencing judge because his failure to file a motion to disqualify waived his argument that the sentencing judge should have recused himself based on the appearance of partiality. Brandt does not assert that the trial judge was actually biased. See People versus Hauser. We will not consider a bald legal proposition presented without an argument or development. See also People versus Doyle. A court's unfavorable ruling alone does not establish bias or partiality. This is the thing that that people like Chille Decastro and who's that attorney out of New Mexico? Blair Dunn. They don't seem to understand that just because the court rules against you doesn't mean that the court is biased against you. At least not biased in the way we're presenting it here. The court will become prejudiced against one side or the other based on the facts presented and the legal arguments made. But that prejudice is based on the facts presented and the legal arguments made, and not necessarily upon any particular feelings either way towards one of the litigants. So, See People versus Lenari. A judge's legal rulings are insufficient by themselves to demonstrate bias or prejudice, and we do not address arguments raised for the first time in a reply brief. Analysis. Brandt contends that the trial court abused its discretion because its sentencing decision was influenced by personal caprice, hostility, and prejudice. The sentence was based on inaccurate information as to whether Brandt was a, quote, psychopath, end quote, and the court unduly relied on retribution to the exclusion of the other sentencing factors. We are not persuaded. First, we conclude that the trial court did not unduly emphasize retribution over the other sentencing factors when imposing sentence. The trial court acknowledged its obligation to consider the statutory sentencing factors and discussed some of those theories. The court also noted and was impressed with Brandt's expression of remorse for his crimes. And the court relied on mitigating factors when deciding that even though Brandt deserved a maximum sentence, the court would impose sentences below the maximum of the sentencing range. Now, I'm not entirely sure how the court came to the conclusion that Brandt deserved a maximum sentence. I mean, maybe it was because of Brandt's long history of arrests and convictions, and the fact that he was out on a deferred judgment at the time. I mean, that might be why the court believed that Brandt deserved a maximum sentence. I just have a hard time with a phone call to a court clerk being the thing. You know what I'm saying? Like, I understand it's a threat, and I understand it's serious. You can't just go around threatening judges. But I'm not sure if that, like, to me, screams, you deserve 6 years in jail. Or prison, I guess, technically. Just not sure. Jasper Kalin, the man of the hour, the man with a lot of research at his fingertips. Ultimately, the trial court stated the sentencing theory that makes the most sense to me is retribution. The court relied on the disturbing nature of Brandt's crimes, even assuming that the overriding element in the court's decision was the nature of the offense. The circumstances of the crime alone may justify the imposition of a lengthy sentence, even a sentence approaching the statutory maximum. You know the weird thing? Here's the weird thing. I'll bet, I don't know if you guys have seen it. You probably have. There's this one video where this judge like rules against a criminal defendant, like on a OR release or something like that, or not violating his probation or something along those lines. I don't remember exactly what it was, and dude just like launches himself up over the judge's bench and like tackles her, and like all the court staff are ineffectively trying to pull him off and everything like that. I'll bet that dude got a lighter sentence than 12 years. I mean, maybe he didn't, but I would expect him to get much more than 12 years if he did get around there. It's just insane to me that he got 12 years for a phone call. I mean, he shouldn't have done it. I'm just, yeah. The fact that a sentencing court finds aggravating factors to be more compelling than mitigating factors does not constitute an abuse of discretion or indicate that the trial court failed to consider evidence of mitigation. As such, we conclude that the record demonstrates that the trial court properly considered the sentencing factors. The court need not discuss each sentencing consideration when imposing a sentence. A reasonable explanation of the sentence suffices. The trial court is not required to engage in a point-by-point discussion of every sentencing factor, but instead, it is sufficient that the record contains information that permits the conclusion that the sentencing court consider all essential factors. Next, while we agree that some of the trial court's comments were concerning, we are not convinced that these statements, when read in context, reflect that the court's sentences were improperly motivated by hostility, caprice, or prejudice. Importantly, the court acknowledged that, despite its feelings, it was bounded by the law and would act within the restrictions imposed on the court. And the court expressed its discomfort at imposing sentence in a case where the victims were judicial officers, and stated that, although Brandt would be sentenced to prison, it got no joy in doing so. Lastly, we conclude that the trial court statements that a person would have to be a psychopath to get joy from inflicting pain, or to get joy from inflicting the pain Brandt inflicted on his victims, did not reflect the court's unsupported belief that Brandt was diagnosed with psychopathy. Instead, we read this lone statement as simply an inarticulate commentary on the nature of Brandt's offense. Conclusion: the sentences are affirmed. I tend to agree, sir. I think he got it. I think he took it a little hard in the old culo. His little rumper dumper pumper got sorely used. Rode hard and put away wet, but not quite in the way that Eric Brandt normally would go for. I would bet, though, that Eric Brandt was a top, not a bottom. We got Nasty Nate in here. Nate would probably know if Eric Brandt was a top or a bottom. Anyway, I hope he finds love in prison. That's all I'm saying. So the next thing we're looking at here, this is Chille Decastro's opposition to the motion to dismiss. I'm sorry, 12B6 motion to dismiss. And I've already gone over why Chille's going to lose just about everything, except he's still got a shot. He does have a shot at the issue of excessive force, because can the video really show it? Well, maybe it can, maybe it can't. I haven't seen the video, so I really can't say whether or not it was. I'm arguing with someone that judges can make orders for the entire courthouse, but the state and federal constitution is working. Can you help? Yeah, go to any court's website and pull up local rules or orders. And among those will be orders regarding the entire courthouse. So, I mean, so the problem. So here's the thing, Navy girl. Here's the problem with these idiots and their judges can't make orders for the entire courthouse. Who's going to tell the judge they can't? If the sheriff or the deputy or the bailiff arrests you for violating one of these orders and they bring you in front of the judge, what are you going to say? You're going to say, well, but Your Honor, you can't make rules for the entire courthouse. You can only make rules for your courtroom. And the judge is going to say, you're telling me what I can and can't do? Well, that's kind of ballsy of you, but it is in the interest of justice and to protect the legal process that I am able to make orders that effectively control the entirety of the courthouse. If you're making a scene directly outside of my courthouse doors, then obviously I should be able to stop that so that I can continue to enact justice. Right. Essentially, a warrant for your arrest is a judge's order. that's effective outside of the courtroom. A search warrant is a judge's order that is effective outside of the courtroom. A domestic violence temporary restraining order, or order after hearing, or a civil harassment restraining order, or a criminal protective order, or whatever other version of harassment restraining orders that you have in your state, is an order of the court that is effective outside of the courtroom. So show me that the only way that could ever get limited would be if the state legislature for state government or for state courts, or the federal government, the federal legislature for the federal courts, if the legislative bodies pass laws signed by the executives of the respective governments that limited the power of the courts to make orders controlling courthouses. That is the only way it would happen. And it wouldn't happen because dummies need to understand that things that happen outside of the courtroom, but in the courthouse, can impact the operations of the court. And so that's like saying a police officer can only make rules for how you conduct yourself in the particular room in the police station that he's assigned to, but he can't make orders or can't make rules for the whole police station. Things like that. It's stupid. But here's my final advice to you, maybe girl. Don't argue with morons on the internet. Once you figure out that they're morons, laugh at them and walk away. You're never going to convince someone who's really stupid that they're really stupid. They don't believe you. They don't take your word. They don't trust your logic, and they're not smart enough to figure it out. So just smile, laugh, walk away. Maybe someday they'll come around. Maybe someday they won't, but there's nothing you can do. So we're back on. This is DeCastro's their motion. The only thing. So if you remember, a lot of the claims, a lot of the initial causes of action were found to be without merit or otherwise barred by the qualified immunity or what have you, and they've already been dismissed. Now, DeCastro repled them, even though they were dismissed with prejudice. DeCastro repled them in his amended complaint. So a lot of those, the court is just going to, my best opinion is that the court is just going to say, I have already dismissed that with prejudice. It is barred. You are barred from bringing it back. It is res judicata. That's a legal term. It's been dismissed with prejudice. You can't raise it again. So I think all of those are already gone. There were a few things related to excessive force that he was allowed to replead with sufficient pleading to make a viable cause of action. It is questionable whether or not he successfully did so. My best guess is most likely he did not, but we'll see. We'll see the way the court comes down. There's also a question as to whether or not the video can or does show whether or not there was excessive force. But here's the interesting thing. Chille is a giant advocate for filming. He wants cops to walk around with cameras, and he thinks to punish people, they should have to walk around with cameras and yada yada. But let's go over this particular part of his opposition. Video exists, but is not dispositive of defendants' factual claims. Defendants rely in large part upon video evidence captured by some defendants, as well as plaintiff, as to the present action. Oftentimes, defendants argue that something is not seen happening on these videos, and while plaintiff maintains these arguments should be rejected, even if they were accurate, they cannot support summary judgment. Pursuant to the trial testimony and video evidence cited by movements, this became a hectic scenario, a factor which was caused by defendants. Certainly, plaintiff was not able to stand back from a distance to capture every aspect of the events once he was wrongfully apprehended, detained, arrested, and handcuffed by the defendants. Therefore, taking the evidence most favorably to the defendant, the failure of a particular seconds-long occurrence to have been captured on video is certainly not dispositive proof that the alleged events never happened. What he's essentially arguing here is that video evidence is not always dispositive. You can't always tell whether someone committed a crime just because somebody else was recording it. Video evidence is subject to some pretty severe limitations. As the evidence must be taken most favorably to the non-moving party, summary judgment is not supported by this type of argument. In fact, plaintiff maintains, notwithstanding the erroneous conviction in a lower state court proceeding, which is on appeal, the video and trial evidence relied upon by the state supports his claims for relief, or at least for the purpose of the present standard of review taken most favorably to plaintiff, leaves in place disputed material facts, which preclude summary judgment as to his claims. Now, what he's saying here is even more hilarious. What he's saying here is that two different people can watch the same video and come to two entirely different conclusions as to what they saw. He's saying that, oh, the defendants, the cops, when they watch this video, they see that the video supports their claims. But when I watch the video, I see that it supports my claims. Well then, like, if you're Chille's whole point all this time about videotaping is that videotaping would be a objective truth. It wouldn't be subjective. It wouldn't be, eyewitness testimony that's prone to error, etc. But here he is saying that two people watched the same fucking video and came to two entirely different conclusions. That's why we still need courts. That's why just having a video camera doesn't solve the problem. Is it true? That's never a good way to start something, but okay, I have a feeling we're gonna run into, I haven't read the entire question, but we're gonna run into the classic, it depends in the law. So let's see what he says. Is it true that only a judge can find a police officer face an unlawful order instead of auditors running around saying that's an unlawful order? Gave, maybe? Is it true that only a judge can find a police officer gave an unlawful order? Well, yeah, all fine. Yes. Only judges can find that police officers gave unlawful orders, at least for our purposes. A police captain might, or disciplinary panel of a police union or whatever, might also find that a police officer gave an unlawful order for an entirely different purpose, i.e. to whether or not to discipline the officer. So, yay. If he's claiming ineffective counsel, why is he still using his trial lawyer for a civil case? Well, because the lawyer was ineffective in one instance doesn't mean that the lawyer is ineffective in all instances. Like, for example, if you order pizza from Round Table Pizza, not that I did, I made myself a sandwich for dinner with no mayo, in case anybody's wondering, that if you order a pizza from Pizza Hut and they screw up your order, well, they screwed up your order, right? That was ineffective assistance of pizzaing. But you call them the next time because you want a King Arthur Supreme, add anchovies, which, again, Dick Bag Patrol is not health advice. It's I like anchovies. But you order next time and they'll make it right, you know? He was ineffective that one time. Okay. So that was my point on DeCastro. It's kind of funny that he's arguing out of both sides of his mouth, essentially. So last and certainly the least, this shouldn't take long. This person put this in. Lawrence, Indiana officer. I got my rights to do anything I want to do. I'm a police officer. Gave me a link to a YouTube short I followed the chain of YouTube shorts and did my own little research, and yes, that's one thing that Jeff Gray does all the time, putting cops on notice and telling them that they're risking their qualified immunity. And I love Jeff Gray. I appreciate the man. I like his work, but it's just so fucking cringy every time I hear him talking about he's put them on notice and he's put their qualified immunity at risk, and last warning to them, or they'll lose their qualified immunity. It's but anyway, I did the research and I found where, well, I guess I could show you. Urban link, and I do tab, but it doesn't show up that way. How did I get it? I had to go to the actual, and I had to go here. So I had to go here, and then I could click on that.
2 shoppers were leaving the mall's parking lot when they saw a cop running their plate.
And you get the idea there. And then I tracked it all the way back to here.
Attempt to make contact with Mr.
But we're still all right. So you can see it's the same cop, same incident. So now we're on the same page. All right. So he says banning the public from recording the police is a reasonable time, place, and manner section. All right. So, couple things. So what happened was this particular gentleman here, he was a deputy constable from Lawrence Township. Deputy constable from Lawrence Township. He was off duty. He was working as a security guard off duty for Nordstrom. And these 2 African-American gentlemen came out of Nordstrom, and he decided to run their plate. They apparently had words with him. It made him a little bit upset. It got his panties in a wad. And so he started barking orders and commands at them to show their IDs and this and that and the next. Anyway, a normal police officer showed up because, well, see, normal police officer wearing a normal police officer uniform, not a deputy constable uniform, and told him this guy beat feet. And anyway, this guy did get fired. I did verify it. He got fired about a week or 2 later. He got fired. He got fired both from the Nordstrom's gig. He was working for a security company. Nordstrom says he can't come back here, and the Lawrence Township constable fired him. And then the driver and the passenger, the African-American gentleman, sued him a couple days later. This was filed on December 10th. The initial stop was on, this was posted November 13th of 2019. So it probably happened somewhere about there. So less than a month later, we have a complaint on file. The gentlemen were suing Daryl Jones, who's I'm assuming is the ex deputy constable, Nordstrom, and On Target Security. They did end up reaching a settlement, a stipulation of dismissal with prejudice. So they had a settlement. Settlement has been reached in the action. It happened relatively quickly. It took about a year. So it was filed on December of 2019, and they had a settlement by November of 2020. So a little less than a year. And so it's all good, right? It's all good. Normally I get these and who's this dude? Who are you, Evil Abe's Meathole Manor, and why are you posting ban user and delete their comments? That's not very nice, sir. I don't know whose address you were spamming there, but oh yeah, homemade mayo is so good. I don't know if they do well. They're normally in like big schools in the ocean. So, oh, look, somebody came back. All right. Not very nice of you, sir. Not very nice. So normally I get these, and I let this gentleman know, and he says that a settlement proves the Lawrence Township Deputy Constable Daryl Jones was wrongfully fired as a sacrificial lamb, just like Salt Lake City Detective Jeff Payne. I don't know who Salt Lake City Detective Jeff. Jesus, ever loving Christ, sir. How are you doing this? How are you doing this? Anyway, oh shit, you're not seeing any of this, are you? This right here. All right. So normally I see these particular kinds of posts going the other way, not where they're trying to say that somehow a settlement shows that a person was, he didn't say not guilty. He said wrongfully fired. I don't think that that the constable was wrongfully fired. I think they had caused based on the way he was running his mouth at these guys and just generally being an asshole. Most law enforcement agencies require their officers to be polite. Up to the point where you have to put them under arrest. And even when you put them under arrest, you still have to be polite and not drop them on their head or something like that. So I do think he was probably rightfully fired. You don't want that kind of hot-headedness as an officer. You're just bound to run into problems as an agency at some point. But normally I see this, like I said, on the other side where people will put this stuff in my chat and they'll be like, this cop's terrible, he's a menace, blah, blah, blah. And then I'll say like, well, yeah, but look what happened. The cop had to pay a settlement. He got fired. He didn't do anything that broke the law, but he was dealt with by society. And it undermines. It's weird. You've got like the James Freemans and the Lacklusters and all those guys who they only show the negative. They only show what cops do wrong. They never show the outcome. Or if they do show the outcome, they go, a cop was fired, right? It doesn't seem to click in their head that like, yeah, the cop did a bad thing. Yeah. And the police force in general fired him because they don't want bad cops. But they'll go right back to, the thin blue line and all cops, protect bad cops, etc. So you have that one extreme where it's just all cops are all bad all the time, and they completely ignore all the evidence of society disciplining the bad cops, not limited to firing, settlement, making them pay settlements, things like that. But then on the other side, you have the whole, all cops are good, and they refuse to look at cops doing bad things, like the cop slamming Caroline in Fort Worth. Like that was, she resisted. Everybody wants to say like because she didn't let her arm get twisted into a painful position, which is a natural reaction people have. And cops can use force to overcome it, but they have to use reasonable amount of force. They have to use a reasonable amount of force to overcome that slight bit of resistance. They can't just pull their gun out and shoot you if you ever so gently pull away, right? There has to be the amount of force used has to be directly proportional to the amount of force used. You'd have to buy me dinner to find out. Well, not giving the name and badge number if you're dealing with the cop, if actually you're a part of the stop. If the cop doesn't give a name and badge number, I would say that's a bad cop. Cops are beat cops, generally speaking. If they want you to submit to their display of authority, they actually have to display the authority. And along with that comes a display of a badge and a name tag, right? Anybody could have a badge. Who's that? Jeremy DeWitt had a badge. You know, you want the full uniform, the full Monty. Give me your name and badge number. So it can be bad. A cop can be doing something bad if they're not giving their name and badge number, unless they're undercover, in which case entirely different set of rules apply. But for a uniformed officer, you know. So anyway, that's all I got for you today. Thanks for watching, and have a great night.